Yes! Hello, my beautiful friends. What an amazing day it is. Welcome back. I hope that your rest was outstanding and your day was amazing and you are ready to go because we got some serious business to attend to today. We're talking about state secrets. We're talking about stays from the Court of Appeals, and Trump came out with an onslaught of executive orders that we're very excited to get into because he's pulling the rug out from more corrupt law firms and declassifying more detailed evidence from corrupt actors, and is even calling out Andrew Weissman himself. We've got election executive orders and all sorts of good stuff. So very glad that you're here and with us. Let me give you a quick preview on what we're getting into, and then we're going to zoom in and get some further details on all of this because we got a bunch of stuff to get into. But let's, of course, see what's happening very briefly. And you can see these are the documents we're going to take a look at. Boom. Notice invoking the state's secret privilege. Woo! Not often we get to talk about state secrets here, at least in court filings. And so this came out from the DOJ over into Judge Boasberg's courtroom. And Judge Boasberg has been a real problem lately, saying that Trump cannot deport terrorists without giving them a hearing, an individualized judicial hearing. And we have been scoffing at this, saying, how about we give them the same due process going out that they got coming in? And so if Joe Biden wants to DoorDash deliver them into our country or give them Uber trips on airplanes, we can Uber them out of the country as well. And that's what Trump is doing. But we'll go through it. We got declarations. Pam Bondi coming up. Rubio coming up. Even Kristi Noem with declarations to this judge, Judge Boasberg, over there in Washington, D.C. Yes, Your Honor, here's what we're doing, because we're members of the cabinet. So it's ridiculous. Of course, all this is going up on appeal, and we're going to keep our eye on the appeal as well. But that's coming up soon. Then we've also got to talk about what's happening out in the Fourth Circuit Court of Appeals, because we had that Maryland case that we saw before from Judge Chuang, I believe is who it was. And he was saying that they had to hire back, right? Elon and Doge had to basically hire back a bunch of people and couldn't access and do certain things. And it was a lawsuit against Elon, right? It was the J. Does. This was, by the way, Norm Eisen's lawsuit. And his law firm was very happy and braggadocious about it. Norm was saying, we won, we beat Trump, because the Maryland judge came out and found in their favor. But not so fast there, Norm, because what has happened is the Court of Appeals has come back down and they issued this order that we'll read through coming up. Pam Bondi's very happy about that. So we'll talk about it. And then we had a slew of executive orders that are a lot of fun. As I mentioned, Jenner and Block, another law firm, getting the block. But thank you. So they get hit with an executive order. They're not happy. Must be level 5 alarm over there. And Trump then came out, signed another one, declassifying Crossfire hurricane. Remember that scam during Trump's first administration. Then Trump was like, I'm feeling lively tonight. How about another one? Boom! He did. Signed another one for elections, saying now we got to protect the integrity of the elections. It's like, how many can you have in one day, Mr. President? Okay, let's keep going. We can do it. Another lap. So he signed that one. We got 3 for 3, some good stuff there. And then to cap the day off, oh my goodness, he pardoned Devon Archer, Biden's business partner. Oh, so there's a lot of different ways to read into that one. Devon Archer, of course, he did an interview with Tucker Carlson and many other people, and we've talked about him a lot here. Seems like an interesting dude. It's weird. Trump is like pardoning Democrats. Kind of strange. Like he pardoned Blagojevich, pardoned Devon Archer, and it's a lot. So as you can see, we got just a ton of fun stuff coming up. Mike Johnson's coming up. Jim Jordan's coming up. They're saying, hey, we want to get in on some of this executive order action. So Jordan is saying, we're going to haul some of the judges in front of Congress. And earlier this week, we had some questions about whether or not the hauling in front of Congress, whether that meant actually hauling the judges in front of Congress or whether it meant bringing in some nice people to just talk about the judges and talk about the, failing judicial system, but have some academic, some professor from whatever, Ohio State, shout out to our friends in Ohio, but you get the point. Somebody we never heard of comes out and tells Congress there's a problem. We go, yeah, we thank you, sir, but we do know there's a problem. But turns out they're going to be trying to drag Boasberg, the judge himself, into court. And so a bunch of cool stuff coming up, and the polls are showing Trump is doing well. So the people out there across the American plains and elsewhere are saying, yeah, this is what we want, actually. We don't want a corrupt and corroded country. We want a country that is functional and works. And so, my friends, we got a bunch of great stuff to get to today, and I'm very excited that you're here. Now, before we get into any of this, let's, of course, say hello to our friends over at The Wellness Company, because our friends at The Wellness Company have a message for us about staying well and being healthy. Now, Elon is now joining the Trump administration, and they're probably looking at all sorts of causes of sickness, right? Lots of people are sick all over the country. You may have seen this. People in your work or people in your life might be getting sick, and they're looking at this stuff in the air, asking what is in it, this weird fog, right? All this stuff that's percolating in the air, this thing about Marqueskins in the air. It's very concerning. But the good news is the Wellness Company has a medical emergency kit that you can see right here that helps you tackle health concerns so that you can avoid hospitalizations and avoid even the need to see a doctor, hopefully. It's got a compact blue case. It's your portable urgent care device, stocked with ivermectin, amoxicillin, Z-Packs, and a bunch of great stuff so you can have it right at your fingertips when you need it. You can literally order this from your couch in minutes. The process is fully digital, and their medical board created a guidebook as well that outlines common treatments and common conditions, bacterial infections, respiratory illnesses, and more. And all it takes is just filling out a digital intake form, and boom, within 1 to 2 weeks, your kit arrives at your door. Very easy. And so don't let illness catch you off guard. Order your kit now. Go to The Wellness Company, and you can go to their website at twc.health/Robert, twc.health/Robert, and use code Robert at checkout. You'll save $30. You'll get free shipping. And these kits are only available to USA residents. So sorry, Europe. So go to twc.health and check it out from our friends at The Wellness Company. All right. So now, without any further ado, and thanks for supporting our sponsors out there, our friends at The Wellness Company. All right. So let's get into it, my friends, because we've got business to attend to, starting right here. President Trump, Pam Bondi, and others now invoking the state secrets privilege. This is a fun one. Of course, this is the case involving the deported Tren de Aragua terrorists. Trump classified them accordingly, but not all of them got deported. Some of the people who are actually suing Trump to stop the deportations, the return to El Salvador, are still in the country. And of course, the case is called JGG et al., keeping the names of the Tren de Aragua people pseudo-anonymous, lest their identities be stolen. But what has happened is they sued, and the judge granted their demands, saying that Trump cannot continue these deportations. And the judge was doing this inquisition, demanding answers on why Trump didn't return the plane. Remember, the plane took off. The judge said, you can't do this. The plane was already in the air. Trump said they were already across state waters, not in the United States anymore. And so we're not returning them. They're gone. Bye, judge. Afuera, out of here. The judge says, well, you should have called them and told them to turn them around, and so on and so forth. So the judge said, give me answers on that. Who made those phone calls? What time, was the plane up? Who was on the planes? How'd the process work? Where'd they land? Blah, blah, blah. Give me answers, said the judge. Now, Trump is responding and saying, no. How about no? These are state secrets that you don't have access to. We are a co-equal branch of government called the executive branch. This judge is not in charge of us. The Constitution delegates to us certain items that we are responsible for. This judge is trying to interfere and usurp that, so we are not going to give it to you. Here's how it sounds in writing. It says, all right, listen, judge, this is in response to the order to give us information. Trump and the DOJ respond. They say, look, the executive branch hereby notifies the court that no further information will be provided to you, Judge Boasberg, in response to your minute order based on the state's secret privilege and the concurrently filed declarations from the Secretaries of State and Secretary of Homeland Security. It's Rubio and it's Noem coming up. We got their declarations queued. They say, listen, Boasberg, this is a case about the president's plenary authority, right? It's broad, it's all encompassing, it's his. It comes from Article 2 and the mandate of the electorate. That's us, the American people. And it's also reinforced by longstanding statute to remove from the homeland this power designated terrorists participating in a state-sponsored invasion of and a predatory incursion into, which is into our country, the United States. The court, Boasberg, you, Judge, has all of the facts it needs to address the compliance issues before it. You know what's happening. You don't need to go in and ask when we took off and landed and who was in charge and more. Further intrusions on the executive branch would present dangerous and wholly unwarranted separation of powers harms with respect to diplomatic and national security concerns that the court lacks the competence to address. It's not set up for this. The courts are set up to be courts. The executive branch is set up to execute the law. Accordingly, the state's secret privilege, Judge, forecloses further demands for details that have no place in this matter, and the government will address the court's order to show cause tomorrow by demonstrating that there is no basis for the suggestion of non-compliance with any binding order. And remember, the judge also scheduled an update. The order to show cause in the law, it's like getting called down to the principal's office. Oh, you're busted. You got to come talk to me and explain why you should not be suspended, son. Not that that ever happened to me. But you get in trouble, explain yourself or else next steps. And that's what's happening right now. The judge has issued that order. I told you not to deport these terrorists. Remember, the gangbanger ACLU lawyers love them. And they're like, we're filing like 50 of them, like filing notices of appearance. Like, I want to be a part of this. I love gangbangers and gangbangers, whatever. But we want to be a part of this. And let me in. And they were all just, piling in like one after another, knocking the door. Ding dong. Hey, I'm here for the gangbanger case. Hey, I'm here for the gangbanger case. Just one after another. It's bizarre. Coming in because they love Tren de Aragua and they hate dictators. Okay. So they all came in. And what happened is the judge granted them and said, you can't deport these folks anymore. This is ridiculous. They have to come explain it. They'll explain it tomorrow, they said. So here's the law. They said, all right, Judge, the president of the United States is a party to this lawsuit. They're suing Trump specifically. They say President Trump is the only person who alone composes a branch of government. Supreme Court said that back in 2020. One person, right? Article 2 says it is vested in a president, not an office of the president. And some people get this wrong a lot. Even I've heard Chuck Grassley get this wrong. We love you, Chuck. It's not in an office of the president. It's in an individual. That's the point. Says, consequently, this court owes President Trump high respect. They do, and they are not showing it to him. And that came from a Clinton case, 1997, right? The judge said, show Clinton some respect in his cigars. That binding command on this court ought to, but to this point has not informed the conduct of the entire proceeding, including the timing and the scope of discovery, right? This is the president of a co-equal branch of government, the most accountable branch of government, arguably, of all of them, because it's all vested in a single individual every 4 years. The whole country stops to vote for that person. So show some respect, Boasberg, who's not elected at all. Constitutional confrontation between the two branches should be avoided whenever possible. They said that in the Dick Cheney case in 2004, saying the separation of powers doctrine requires that a branch not impair another in its performance of its duties, right? Courts don't hurt your co-equal branch. You're on the same team, Team America. You're not supposed to be insurrecting the operation of the government officially from your dark robes. Judicial deference and restraint are required to avoid undue interference with the executive branch. Nixon versus Fitzgerald, 1982. This is necessary, Boasberg, to avoid the current collision course in which a single district judge, you, James, has unnecessarily put himself in an awkward position that includes the difficult task of balancing the need for information in a judicial proceeding and the executive's Article 2 powers that they're entitled to under the Constitution. So in this case, invocation of the, quote, absolute state secret privilege prevents the court from colliding with the executive. Sorry. In the District of Columbia in 2007, there was another case that was sealed and another case in 1982 that said the critical feature of the inquiry when we're debating these things about whether the court needs this info and when the plane take off and all that crap, the question is not the balancing of ultimate interests at stake in this litigation. It's whether the claim of privilege is more important. The state secret privilege is a common law evidentiary rule that protects information from discovery when the disclosure would be inimical to national security. The privilege may be formally invoked by the head of the department, which has control over the matter. The government need only establish that the requested information, what this judge wants to know, poses a reasonable danger to secrets of state. The issue is whether the challenged disclosures may harm, right? May, not will, or poses a reasonable danger, doesn't need to meet some standard of like beyond a reasonable doubt that it will cause harm. It's just may. It's a lot lower standard than probably what this judge is going to interpret it as. Let's see. Now, judicial review of the invocation is limited. Okay. In other words, once the executive branch invokes it, says it's like the Uno card, whatever that one that you can't reverse, it kind of ends everything and they drop it and you're like, oh, you little, I can't believe you had that whole time. Oh, it's like that. Where'd that, nope, don't ask. You lose, it's over. Don't even think about reviewing it. And the degree of judicial scrutiny varies according to the importance of the information sought. It's limited, right? You can only view this in limited fashion. The court must afford great deference to the executive branch. This includes being careful not to force a disclosure of the very thing that the privilege is designed to protect. Another case said, the district court, like Boasberg, need not have complete knowledge of how disclosure would even affect or cause a security breach. Judge, you don't need to know why it's bad for you. Where there was only a trivial showing of need for the disclosures, in this case, the judge just wants to punish Trump and the executive branch and hold them in contempt, issue sanctions, create an impeachment trap, create a political narrative that Trump violated a judicial order. He deported terrorists. I can't, while they're hanging their hat on this one, but all right. And the circumstances of the case point to a significant risk of serious harm if the information is disclosed, and the trial judge, in this case Boasberg, should evaluate and uphold the privilege claim solely on the basis of the government's public representations without an in-camera examination of the documents, right? So think about this like in COVID terms. You sue the government, you say, you're wrecking my life, my business, you're trying to kill us, whatever your claims are, all valid in many instances, would be looked at and scoffed at by the courts. They would just say, well, no, I mean, the CDC says you have to do this and you have to close down or we're going to die or whatever. And you say, well, I'm challenging that. They would say, well, in good faith, we're just going to look to what the executive branch said needed to happen, which is to close you down and deport you from the military if you didn't get the thing, and deport you out of fire departments and police departments and other institutions. You get deported out of those entities. You sue, say, you can't deport me out of this. I'm an American citizen. I have rights. How dare you, judge? They say, shut up. Close your gym down. You conspiracy theorists, close it. And then if you sue, you get no benefit of the doubt. They're not looking at this like these poor, deported gym goers deserve rights or anything. In fact, they look the other way in this case, right? In other words, during COVID, they gave the government, their fellow executive branch, every benefit of the doubt. The CDC got patted on the back. They said, well, we just defer to them. They said that this is good for America. They said, okay. Well, we're saying the executive branch is saying these people are bad for America and need to be deported. Now the courts are saying, how can you sue? How can you do this without any process? Where was that due process back during COVID? It didn't exist. So the courts are just, they just the default good faith benefit that they would ordinarily give to their co-equal branch of government because they're on the same team, they're not affording to Trump because they're judicial insurrectionists. So the information sought by the court, writes Trump, in invoking the state's secret privilege, sought by the court is subject to the state's secret privilege because disclosure would pose a reasonable danger to national security and foreign affairs. And because there is no need for this information other than to try to catch Trump, this court must resolve the application based on the declarations submitted with this motion that have come from the cabinet. We'll read them in a minute. They say, here's why, Judge. Now, the state secret privilege reflects the reality that it is the responsibility of the executive branch, not the judiciary, to weigh the variety of complex and subtle factors in determining whether to disclose information and whether it may lead to an unacceptable risk of compromise. That came from 1985. Another case called CIA versus Sims, right? That's why we have an executive branch, so that it can act with expediency and not be bogged down by courts and committees and process. Trump's execution of his Article 2 authorities, which are of unrivaled gravity and breadth and include managing matters that are related to terrorism and immigration, requires the utmost discretion and sensitivity. You can't come in there. It'd be like Trump going into the judiciary and telling this judge who he can fire and who he has to work with and how he needs to run his courtroom. It'd be ridiculous. As such, when the government invokes the state secret privilege, no competing public or private interest can be advanced to compel disclosure. So you can't challenge us. The Secretary of State's declaration from It's Rubio confirms that the removal of the alien enemies at issue, namely alien members of the designated foreign terrorist organization called Tren de Aragua, said were the product of non-public, sensitive, and high-stakes negotiations with one or more foreign countries. He says disclosure of the information that's requested by the court could cause the foreign state's government to face internal or international pressure, making that foreign state and other foreign states less likely to work cooperatively with the United States in the future. That disclosure would also be viewed as a breach of trust. It would impair foreign relations and the diplomatic capabilities of the U.S. The end result, Judge, if you do this, would be to erode the credibility of the United States and our assurances that when we engage in these negotiations, they will be engaged with in confidence and impede our ability to do this in the future. Other cases have even said disclosures, public disclosures, can diminish the extent to which intelligence agencies of countries A, B, C, and D will cooperate with our own intelligence agencies in the future. They cite the Halcon case for that. They say also, yeah, diplomatic relations is something covered by the state secret privilege. And the privilege, if it needs to be invoked when it otherwise would disrupt diplomatic relations, yeah, in this case, it also recognized that. Diplomatic security is a lawful basis to invoke the state's secret privilege. So Trump continues from the DOJ, writing, moreover, Judge Boasberg, Secretary of Homeland Security Kristi Noem has also established that responding to the court's inquiry, so now she's coming in, so we got Secretary of State, that's one. We got Noem, number two, saying this would directly compromise the safety of American officers, contractors, aliens, and the American public. Judge, this is crazy. You're going to divulge critical means and methods of law enforcement operations about how we rounded up these folks? And you're going to confirm operational details? It's going to cause harm to national security of America and undermine the efficacy of our counterterrorism operations. And disclosure, Judge, would allow others to draw inferences and insight in how future operations would be conducted. And that's not good for national security. Then they would be able to stitch together an understanding of the means and methods that we use, and then they could try to thwart our law enforcement. So courts are in no position to gauge what constitutes an acceptable margin of error. They're not set up for that. We get to set what these policies are and how this works. And so the court lacks competence to evaluate the risks that are associated with this, or the mosaic effect whereby bits and pieces of data may aid in piecing together bits of other information, even when the individual piece is not obvious or of obvious importance itself. For example, they say, Judge, look, confirming the exact time the flights departed, right? This judge is like, when did my verbal order, the judge said, turn those planes around, paraphrased. Then after the hearing was over, he went back to his chambers or wherever, wrote up the order. The written order then came out. Trump says, well, after the written order came out, everybody was already in the air and we're not turning around at that point. Judge says, well, I said in court, turn him around, and that's when you should have turned him around. Like like I said, now. And I mean now. So go do it. And they didn't do that. So he's trying to pinpoint the exact time. Now, or their particular locations at some other time, like when they landed, or where they were in the air, like where were they specifically? Judge's like, okay, were they over Texas or were they over El Salvador? That would facilitate efforts, Judge. If we tell you this, then they're going to track our other flights. They're going to know what's going on. In turn, disclosing any information that assists in the tracking of the flights would both endanger government personnel operating those flights and aid efforts by our adversaries to draw inferences about negotiations and coordination and more. And so simply put, this court, Judge Boasberg, has no cause to compel the disclosure of information from the executive branch that would undermine or impede future counterterrorism operations by the United States. We're going to continue to do our job. Thanks, though. And finally, the fact that there are allegations and claims in the public domain regarding issues implicated by the court's questions is not a basis for vitiating the privilege. He's saying, well, the judge said, you posted videos of these dudes being taken out of the airplanes. So what's your state secret there, right? You saw them coming out in El Salvador. You saw them being marched in. It's like, it's like rock music in the background, F-16s or whatever, fighter pilots, terrorists, being thrown off the buses. Oh, you're like, rock on America. So the judge is saying, what the hell? If you can do all of that, why can't you tell me? They're saying, well, that's not enough. Official confirmation of any of those allegations would pose a distinct threat. So there are claims from people who watch this footage, but maybe that footage is not even the real footage, or maybe, whatever it is. So that doesn't give them operational intelligence. So official confirmation, though, of any of those allegations, if we said, yeah, that came from this and that came from this, that would pose a distinct threat. The fact that that information resides in the public domain does not eliminate the possibility that future and further disclosures can actually harm intelligence, sources, methods, and operations. And so thus, even though some information has been in the public domain, the rest of the information can still be a state secret and thereby privileged. So accordingly, the declaration submitted from Noem and Rubio coming up establish a valid basis for the state secret privilege. We don't need to give it to you. And they're also dispositive. So stop asking any further questions. This is a dispositive notice for ceasing, Judge, any further inquiry into these flights. You're done. Why? Also, there's no need for any of this information. The quote, need for the information at issue here is only relevant to the court to help determine how deeply to probe the details and the basis of the government's privilege claim. So you're just trying to examine like what the privilege is for or how far it goes. But that's not needed for this case. Here, because the necessity for that information is dubious at most, a formal claim of privilege will have to prevail. Trump wins by default. You give them the good faith basis, the benefit of the doubt, and they win. Now, the information sought by the court is irrelevant to their claims. The people who are suing to keep the Tren de Aragua terrorists, the gangbanger ACLU lawyers, are going to have their claims regardless of when the airplane took off, right? The only reason they want the information about when the airplane took off is to say you violated the order. That's all. But it doesn't impact their claim. Their plaintiffs, by the way, have not even been deported. So the court has already devoted more time to these inquiries than it did to evidence and argument on the issue of whether a class of terrorists should be certified, and the judge certified them. Class action lawsuits in America by classes of terrorists certified by Washington, D.C. judges in America. Tell your friends that's what's happening. Yeah, maybe they'll get a big fat settlement and they can all go on vacations to Disneyland together. So in any event, the government has already confirmed that 2 flights carrying aliens being removed under the Alien Enemies Act departed U.S. airspace before the court's minute order of 7:25 p.m. Judge, we already said they're in the air. Once they're in the air, we're not turning them around. We notified you. That's all the information you need. And the government has not contested for purposes of these proceedings that the planes landed abroad. We know that. You're like, when they land, what time? They landed abroad, and that aliens were aboard. They were deplaned. And after the issuance of the court's minute order. Okay, so they're even agreeing. Look, we admit that they were in the air when your order came out, and they landed after your order came out. And they got off the plane after the order came out. So we're admitting we did not turn them around. We could have. Right, that's kind of implied. To have proceeded otherwise and to have turned planes around mid-air, right? This is what the judge is mad about. Why didn't they come back? Without regard to important logistical constraints like fuel availability or foreign airspace restrictions, the judge is like, refuel your plane over the Gulf of America. Bring those terrorists back. We want them here. Especially on the legally infirm basis that the court even retained authority over aircraft operating outside the United States, that would have implicated grave safety risks. And so, Judge, no more information is needed for you to resolve any legal issue brought in this case. Whether the planes carried one TDA terrorist out or 1,000, or whether the planes made one stop or 10, simply has no bearing on any relevant legal issue in this case. The need for additional information here is not merely dubious, according to case law, or trivial, according to another case. It is non-existent. You don't need it other than to go, the subtext here, to just go and try to incriminate Trump, to sanction Trump. The executive branch violated no valid order through its actions, and the court has all it needs to evaluate compliance. And so, therefore, Judge, this inquiry should end. Now, with the utter lack of need for the information that the court seeks, the court must address then. You have no need for this, so you have to address this with that basis. You must address the invocation of the state secret privilege on the basis of the declarations and without in-camera review of the information at issue. Meaning in-camera review would meaning the judge would look at this in chambers, off the record, essentially in private. It's not required as a matter of course in this, so you don't get to decide whether you need it or not. You can't even look at it. The other court and others said if you haven't established a good need, then the court should not jeopardize the security, even by the judge alone. You shouldn't even look at it, Judge. When the privilege involved is based on a concern about diplomatic secrets, courts should not insist upon examining the evidence. That came out in a 2021 case from D.C. Courts are not required to play with fire and chance further disclosure, even if it's inadvertent, mistaken, or even intentional. That would defeat the purpose of privilege. So the Supreme Court has also provided that when a judge has satisfied himself that dangers asserted by the government are substantial and real, he need not, indeed should not, probe any further. So that is the appropriate course in this instance. And so for the foregoing reasons, the government invokes the state secret privilege and hereby declines to further respond to the court's minute order. Sincerely, your friend, Drew Ensign. Thank you, Drew. Amazing filing there from the attorneys out in Washington, D.C., from the Trump DOJ. Sending that one off to Judge Boasberg, who we've seen and covered here for a long time, is trying to catch Trump in ultimately an impeachment trap. It will go through order to show cause, which we'll be back on tomorrow. They'll say that, we'll see what the judge says. I tend to believe he's not going to hold them in contempt or issue sanctions. He might just scold them and then kind of weenie out of this. But he could go the other way. Hold the DOJ in contempt, issue sanctions, do something like that. Trump, of course, is already appealing this. And we now know that they are supported in this effort by 3 Senate-confirmed Trump appointees, Pam Bondi, Marco Rubio, and Kristi Noem, all here. Let's start with the DOJ. Pam Bondi sent this one into Judge Boasberg. She said, I, Pamela Bondi, declare under penalty of perjury the following. I am the Attorney General of the United States, and I advise other agencies on how to handle law and legal questions. The purpose of this declaration is to protect the national security and foreign affairs interests of the United States by joining, in my official capacity, writes Pam, the formal assertions of the state secret privilege over the information that Boasberg wants, saying the statements made herein are based on my personal knowledge and in my official capacity and on information I've received. Here's what happened according to Pam. Following the public issuance of the presidential proclamation, on March 15, DHS, Kristi Noem, successfully removed by aircraft a number of aliens subject to Trump's proclamation. Those removals were facilitated by the Department of State, its Rubio negotiations with foreign countries. Then in March 18th, the court requested the following information about those removals. The judge says, I'm the president now, and I want to know what time the planes took off and from where, right? Like everything. What time they left U.S. airspace, what time the plane landed, where they landed, whether they made more than one stop, what time the aliens subject to the proclamation were transferred out of custody, how many aliens aboard the flights were based on the proclamation and other sources, blah, 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 right? Everything. This judge's like, I'm in charge. Now they say, no, you're not getting all that. The Secretary of State and Homeland have each submitted a declaration, we'll read those next, asserting a formal claim of state secrets. Those declarations reflect the studied and well-supported conclusion of each secretary that disclosure, even ex parte, even in camera, would cause significant harms to foreign relations and national security. And so Pam says, after considering all relevant information, including the declarations of Rubio and Kristi Noem, and the following independent legal review by DOJ personnel, I'm satisfied, says Pam, that the assertions of the state secret privilege are warranted and supported, and I join their assertion of that privilege. Signed by Pam Bondi, Attorney General of the United States. So that's one. Then we come back and look who's next. It's Rubio. He says, hey, guess what? I'm the Secretary of State. I handle foreign affairs. Now, the statements made are based on my personal knowledge and more. And what I am writing to do is to assert a formal state's secret privilege. As explained, disclosure of the information covered by this privilege would cause significant harm to foreign relations and the national security of the United States. I've discussed with knowledgeable State Department employees the details of this information, and I think that this privilege is appropriate. Here's what Rubio says. In the course of my official duties, I'm aware that Trump issued an executive order labeling terrorists as Tren de Aragua as terrorists, saying they've engaged in a campaign of violence and more. He says, in the course of my official duties, Rubio said, I designated TDA as a foreign terrorist organization. He gives us all the authority there. So in the course of my official duties, I'm aware Trump also invoked the Alien Enemies Act. And I'm aware that this lawsuit is about that. Now it says, in the course of my duties, Rubio, I've been informed that this court has ordered the defendants to disclose a bunch of info. Where did they leave? Where did they get there? What kind of, lunch service did they have, and all the things. After careful and actual personal consideration of this matter, it's Rubio says, I have concluded that the disclosure of this information could reasonably be expected to cause significant harm to the foreign relations interest of the United States. And so, when the United States seeks to remove individuals from a foreign country, we must negotiate this stuff. This requires sensitive, high-stakes negotiations. They cover sensitive issues. People have to be willing to accept these things. If you compel us to disclose the number of aliens aboard, including what's asked for in the minute order, and the reasons they were aboard, that threatens significant harm. For example, if we were compelled, if this disclosure came to light, it would cause foreign states and their governments to face internal pressures. And they're not going to work cooperatively with us in the future. We're going to have less robust relationships, and disclosures are going to undercut the State Department. Foreign states are not going to want to work with us anymore. And when the United States seeks to remove individuals to foreign countries, it likewise must negotiate the logistical details. Those are sensitive. They're negotiated outside the public view. We have to talk about timing and destination. We don't want that information coming out in whole or part. Then they might not want to accept them. It's going to threaten all these confidential matters and damage our relationship with our allies. And so we cannot answer these questions, like what time they took off, the time they left airspace, and more. We're not giving you our flight plans, Judge. And likewise, compelled disclosure of that information, says Rubio, could reveal whether an alleged deportation flight touched down in a third country. Neither the United States nor the foreign state to which removal is being made would threaten significant harm. Now, whether a particular flight carried out for a particular purpose is a sensitive thing. Compelled disclosure of that would breach trust, threaten the willingness of other countries who may not even be unaware of the nature of the purpose of the flight, and could cause a problem there. It's critical, says Rubio, to bear in mind that removal operations can be, as they are here, counterterrorism operations too. If foreign partners believe that any relevant details could be revealed to third parties, those foreign partners would be less likely to work with the U.S. That impairs the diplomatic relations and capabilities of the United States and threatens to harm our security. Rubio continues, saying if foreign states believe that information sought by this Judge Boasberg could be revealed simply because a lawsuit has been filed, it would erode the credibility of the United States. We have to protect our info. We can't have terrorists suing to get information on terrorist deportation operations. Do you hear how insane that sounds? Again, this threat to the United States extends beyond the removal context. And so importantly, the compelled disclosure of this sensitive information would cause harm to the United States. Even if some of this came out publicly, like we know we deported them, but the details matter. The disclosure of foreign affairs information is vital to the United States that does not happen. There is a difference between official acknowledgement and informal reports. And so we're not going to confirm or deny the accuracy of any of those disclosures or any of those videos or speculation and more. And so finally, Rubio says, for at least two reasons, the compelled disclosure of the information sought in this minute order threatens foreign relations, even if you look at it ex parte or in camera. First, having a judge look at it is going to be seen as a breach of trust. We are negotiating with these foreign entities. It's our job to do that, not your job to peer over our shoulder. The sharing of sensitive, non-public information with a judge it's not between the judge, it's between our nations, and the people have elected Trump to manage those affairs. Indeed, any order based on this information would lead to public dissection and speculation about the basis for the order, and that increased public dissection and speculation threatens the significant harm that's already been discussed. We're going to have reduced cooperation from our partners, and I declare all of that is true. Signed by, it's Marco Rubio here in the Secretary of State position, writing in to Judge Boasberg saying, I also agree, you're not getting these records. Now, one final submission to Judge Boasberg comes from Kristi Noem, Secretary of Homeland Security. She says much the same, says, I am here discussing with my employees and more what happened. Said, in the course of my duties, I know that Trump issued these orders, and I'm aware that he also invoked the Alien Enemies Act. Now, in the course of my duties, I have been informed that this court has ordered us to disclose all of the details of the flights, Kristi Noem says. After careful and actual personal consideration of this matter, I, Kristi Noem, have concluded that the disclosure of this information could cause significant harm to America. Here's why. First, disclosure information about removal flights, including confirmation or denial or speculation, directly compromises safety. Removal flight plans, including locations and the paths and where they land and how long they travel, it's all law enforcement details you can't know. Even where discussing a past operation, disclosing, denying, confirming, or sharing any other operational details would cause harm. This could allow others to draw inferences and insight into how the government works. This is how they did it before. This is how they'll likely do it again. Now, in addition to flight operations, the number of TDA members on a given removal flight would also expose sources and methods, means and methods, and reveal key details about the operations, allowing other people to draw inferences and more. Revealing or confirming this also would allow our nation's enemies to determine how they best can utilize these sources, right? Whether they were removed based on a proclamation or some other power of law, when they bring their challenges and claims, they'll just say, well, this is how they're doing it because this is how they've done it before. Removal operations involving gangs are also similar to counterterrorism operations. If we had disclosed any of this, that would directly help those groups literally avoid capture. Maybe that's what this judge wants. It would also directly undermine the efficacy of American counterterrorism operations. So if we disclose what this judge has ordered us to disclose, there will be significant harm to the United States. It is both true and well known that official acknowledgement of a fact may be damaging to national interest in a way that informal speculation is not. People could stitch together exactly what's happening here. And if we also disclose this stuff, we're not going to be able to work with foreign nations anymore. These are sensitive matters, and we have to cooperate with other countries. There are non-public, sensitive, high-stakes negotiations that must be negotiated, and we can't be compelled to disclose that. If that were to come to light, there would be internal or international pressure about what happened here, and they're not going to work with us in the future. And so if a disclosure were in any way to undercut, even in the eyes of a foreign state, whether it was fair or not, if it casts doubt on them, that's going to impact all of us. And the judge is not set up to manage this. It's not a political body. It's supposed to be. It has become that, unfortunately. Likewise, if you compel us to ask whether we touch down in a third country, that would threaten significant harm to the United States. Whether a flight may land in a third country is a matter of sensitive diplomatic discussions. And foreign states may not be willing to talk about that, right? Like, in other words, maybe if we landed in Mexico, maybe the Mexican government doesn't want to talk about that. Like, well, we kind of let them use that landing strip. But if the people found out about it, maybe they'd be upset about it. Like, why are you letting the Americans land here to deport the Venezuelans? Something like that. So you cannot damage the U.S. relationship in that manner. It's critical to bear in mind that removal operations can be, as they are here, counterterrorism operations. And if we compromise these, they're not going to want to work with us. We can't even be forced to confirm or deny these things. And finally, for at least two reasons, the compelled disclosure also threatens national security. Even if you look at this in chambers, the mere act of giving the information to this court will be seen as a breach of trust. Oh, someone can sue and some hack loser judge can just order it be delivered to his chambers and you have to oblige? Okay, how about we just don't do business with you anymore? Second, as a practical matter, the more widely information is shared, the greater the risk the information will reach the public, even if it is unintentional. We can't trust your seals or your protection. So it may cause direct threats to the United States, and it's going to damage cooperation from other states as well. And so all this is being signed by Kristi Noem, Secretary of Homeland Security. So 3 for 3. Homeland Security, Secretary of State, and United States Attorney General all coming together with shared declarations explaining to Judge Boasberg, you don't have the power to get these materials, nor is it in America's interest to give you these materials. So go back to your chambers and pout if you want to, but you're not getting them. Now, the judge has received that. We'll see what the judge does in response to this. But the judge came out and said, okay, we've got a new minute order here. The court orders that if the plaintiffs, the terrorist and ACLU gangbanger lawyers, if they want to respond, they shall file a response by March 31st. And so this is so ordered by the judge. So we'll see what they say. They're obviously going to say that Trump cannot invoke state secrets privileges here, must give the documents over because they're facilitating this on behalf of terrorists, alleged terrorists by President Trump and the State Department and Homeland Security wanting to ensnare Trump in something much broader than this, in this case, an impeachment trap. So we're going to be here continuing to cover this one, my friends. Thank you for subscribing and joining as we do. All right, now we're not done yet. We got to turn our attention here to another case that was a nice victory, temporary victory for now, but we're happy to see it. And here is what it looks like. Yes, Pam Bondi also celebrating this one. Pam Bondi celebrating a win in the Court of Appeals. We've seen a ton of TROs and preliminary injunctions come out from hack judges, stopping President Trump and the American people from having their will implemented into the law. But we have a good order that's come down in the case brought by the J Does 1 through 26. And we know here in the FBI Does case and in the J Does case, we have the disgusting fingerprints of Noem Eisen. Yeah. And so we'll come back on that. But Pam Bondi was happy with this ruling from the Court of Appeals today. Said this is a positive development in the DOJ's ongoing court battles against judicial overreach from activist judges. Says our attorneys will continue fighting to ensure that President Trump and Doge can carry out their important work of saving out American taxpayer dollars. And so let me show you the filing that caused this to happen. Of course, we'll see where this goes because this is just the preliminary phase of the Court of Appeals phase, right? It's just asking for a stay. It's not total victory that we're going to be able to take and spread around all of the other districts or circuits, but it is a nice development, right? And the question, of course, becomes, are these judges, once we have these cases percolate up to the Court of Appeals, will we have some sanity come back into play? Because right now we have judges, it's kind of a free-for-all. It's chaos, the wild, wild west. They're doing whatever they want because Judge Roberts and Amy Coney Barrett just have other things to do, I guess, for now. But here's what Trump's DOJ submitted that resulted in a nice stay. We'll come back to it. It says, all right, Court of Appeals, Fourth Circuit, we're coming up from Maryland, and they write, all right, Court of Appeals judges, they say the lower level court issued an injunction against Elon Musk, an injunction that will stop Elon from dismantling the USAID entity. So this court should stay the lower level court's order or in the alternative, enter an immediate administrative stay while it considers our appeal. And at the very least, you should also stay the preliminary injunction because remember the judge said even Jeremy Lewin, who was a properly appointed official, could not run the agency, right? The Maryland judge said you can't even have him operate the branch. We just appointed him. What? Here's what they say to the Court of Appeals. They say, look, even the people suing Noem Eisen's law firm, they agree that officers of the United States are the only officials who exercise significant authority pursuant to the laws, and they occupy a position that's established by law. Now, they offer no reason in their lawsuit to conclude that Elon Musk meets either of those, let alone both tests. The district court at the lower level acknowledged that Musk has no formal legal authority to make the decisions at issue. That's enough. He says he has no legal authority. There is no formal authority. They're suing under the Appointments Clause. The Appointments Clause applies to people who are in positions of power with formal authority. They do not seriously claim that Musk has any such authority because he doesn't. Instead, they describe ways in which Musk's influence has influenced the government actions, suggesting that influence, this is what they're suing over. They're not even saying he has power. He has too much influence by their own words. At times, they say it's been too decisive. So they tip their hand here when they describe the range of USAID actions, but they decline to state that Musk took those actions or that Musk even had the authority to command those who did. They said that USAID officials were placed on administrative leave, right? Or the USAID website had been, see that past tense language? It's very passive. They were placed. Okay, why don't you use some more active language? Who placed them on the thing? Who did the thing? Were placed, by whom? Plaintiffs also allege that at other agencies, not at issue here, Musk, quote, intimidated officials who may themselves have the authority to act. So Musk is just too, I guess, imposing. Yeah. Now, even if were that true, it would not mean that Musk can issue binding decisions or otherwise make any, he walks in and says, you guys are acting like idiots. So like, well, I guess we are. And they fix something. They say Musk intimidated them. That means he holds no office established by law, and he's not an officer, right? So they're even admitting it. Now, they underscore their error of their position when they assert that Musk has, quote, more power than a typical advisor. Presidents have broad discretions on who to work with and who to select as advisors. 1993 case from the DC Circuit, which is where we are. And some presidential advisors can be, in a colloquial and practical sense, extremely powerful. But even the most powerful advisors do not exercise significant authority pursuant to U.S. law when they lack authority to make decisions legally. Significant or even decisive influence does not offend the Appointments Clause so long as a duly appointed official has the final authority. And so this court should reject Norm Eisen's invitation to adopt an ad hoc and ill-defined metric aimed at measuring how much power an advisor wields and then deeming that advisor an officer, okay? We're just going to make this person, Elon, an officer, even though he's not formally in an office, because he's so powerful. Now, even as to two discrete actions that they brought up, calling shutting down the headquarters and the website. Remember, the judge was mad about this. Like, you shut down their building. Give their building back. Plaintiffs seem to admit that Musk is just one of a set of individuals known to be associated with those acts. So they can't even prove that it was Musk. The absence of evidence does not warrant drawing inferences about Musk's role. Regardless, plaintiffs do not dispute the district court's own statement that Musk lacked the authority to make these decisions for the government. And that's all that matters, okay? You can't just say he's too powerful and so therefore we have to sideline him. Nor do plaintiffs rehabilitate their other contention that Musk occupies a position by law. They rely entirely on the view that Musk performed the duties and the functions of the administrator. But the Appointments Clause does not apply to de facto power, separate from a legally established office, and their argument wrongfully conflates Musk's functions with whether he actually occupied the office. They say that Musk exercises influence at two levels of removal. First, he influenced U.S. Doge, and then he used Doge to influence other agencies. But that weighs against the idea that he occupies an office, right? Even if, like, in other words, even if you accept what they say as true, that shows he's not in an office. He influenced Doge, and then Doge influenced agencies. You still are admitting he's not occupying an office. And they can't have a forward-looking injunction when all of this was to past behavior. Then they try to conflate this. They say, well, Elon should be in a position, and they try to make it up. They say it's also a separation of powers problem. Initially, they are suing, saying that the USAID has been dismantled, right? But by their own telling, no, they even admit USAID employs a significant workforce, right? We've been saying this for a while. It's cutting and bulking. And right now they're cutting, but they haven't dismantled or eliminated the agency wholesale. Indeed, the record also demonstrates that USAID retains employees deemed essential for various things. As stated in another declaration, they also planned actions like securing the effective delivery of an HIV relief program and other global health supply chain stuff. So they're around. So stop saying they're dismantled. They're not. They're there. They don't have a headquarters anymore. They don't need it. Plaintiffs also fail to explain how the injunction addresses a separation of power problem. The injunction does not require USAID to resume its halted operations. Indeed, because plaintiffs named no USAID officials, there are no serious questions about traceability and redressability. They do not even respond to redressability. In fact, the order may prevent USAID officials from trying to increase operations because they can't access or do anything. So in all events, their separation of powers theory should also be rejected. This court should reject their invitation to transform all of these into claims. They created their own constitutional problem. They're asking a court to superintend an agency by declaring that all of the agency's actions are unconstitutional. That is a separation of powers concerns. By having a judge cross the line and tell us what to do, that is right there. You got it. Their other case law doesn't advance their claim. We can reorganize USAID. The status has legal consequences and more. Congress placed the administrator under the direct authority of the Secretary of State. Numerous administrations have also reorganized USAID. Even Bush took a major transformation of this and eliminated several USAID offices and did all sorts of stuff. So stop your crying. Now, Noem's lawsuit plaintiffs also do not dispute that Congress recognized Trump's authority to eliminate or consolidate or transfer these things. Instead, they said, we didn't get enough justification to Congress. It's undisputed. Rubio did provide some notice to Congress. Whether the notice was sufficiently detailed for you, we don't care. Now, plaintiffs have never shown any irreparable injury that this court could remedy. They don't even defend the district court's reliance on reputational injury. They urge that some personnel overseas on administrative leave might lose access to their emails or whatever, but plaintiffs do not dispute that USAID is acting to ensure that they retain access. Like, we're not cutting them off of their emails. They're fine. And this is harming the government. The injunction intrudes on a coordinate branch and prevents USAID from functioning because this judge has barred the COO from even operating the agency. And this COO is not even named in the lawsuit. So at a minimum, the court should stay the preliminary injunction as to Lewin, right? Because the judge said he can't even be in charge because he's too dangerous or whatever. They don't even argue that Lewin was ever an improperly appointed officer. He was. Nor did they dispute that Lewin was even doing anything bad. Instead, they urge this court should defer to recusal, but this has no basis in law. They shouldn't sideline this guy. He is not, never has even been an employee of Elon or Doge. They illustrate their misunderstanding by saying he's a part of Doge, but he's not. There's no sound basis for recusing Lewin from any prior work, and you can't sideline him. Each consideration weighs against what this lower level judge did, and so they're on no firmer footing in saying that they want to sideline this guy, saying, well, he caused these past problems, and so he can't continue to run the agency, right? He's not a defendant, and the fact is, he is one of a number of people who've worked here. The district court made no findings to this effect. And even if he did have the authority to make past changes, they would still bear little relation to the prospective recusal. The injunction has no effect on the core changes. And so, in conclusion, we would like a stay signed here in the Court of Appeals for the Fourth Circuit, coming up on appeal from the District of Maryland. And so the judge came back down and granted it, at least as follows, says, all right, from the Court of Appeals, from the Fourth Circuit, the J. Doe's case, they say on the defendant's motion for a stay, the court orders that the district court's preliminary injunction, and as clarified by its second order, be stayed. And the whole thing is hereby stayed until the close of business on Thursday, March 27th, 2025. So this judge came back out. Nwamaka Anoe, it's the clerk. Nwamaka Anoe signed that. And good news. So stayed for just a few short days. We'll see what comes back on that later date. Probably some other hearings or something scheduled. But a nice development there. I'm sure the lower level judge is not happy about that, but we'll see what happens next. So we're going to keep our eye on this one. And remember, this is Norm Eisen's case. Norm Eisen, the last time the judge issued the order, was out doing cartwheels and backflips all over Jen Psaki's face. And now all of that is stayed. And I think we're going to see a lot more of this. As the courts of appeals start to flesh through these issues, they're going to have no choice because these lower level judges have gone hog wild and they're digging holes for themselves that they're not going to be able to climb out of. And so the courts of appeals and the Supreme Court will come back to settle this soon. All right, we got one final update, my friends. And then we are going to hear from you. We got a bunch of executive orders. Trump unleashes the motherlode of executive orders. We've got several to go through today, including one that's going after Andrew Weissman. You know him from all the cable shows. He shows up there and screeches about Trump and how the DOJ is amazing and their prosecutions of Trump individuals and more. But his former law firm is getting hit. We got the executive order on that. We've got another executive order on the declassification of Crossfire Hurricane information. This is the Russian collusion investigation and hoax from the first term, and another one on the integrity of American elections. And so a bunch coming up. But let's start with the first one from the president here today, which is an executive order targeting Jenner and Block. Here is how it went down with the president and his team.
Taken action against a number of law firms that have participated either in the weaponization of government, the weaponization of the legal system for political ends, or have otherwise engaged in illegal or inappropriate activities. The law firm of Jenner and Block is one of these law firms. This is a law firm that, as you know, employed Andrew Weissman after he came off of the Mueller investigation. It's a law firm that's engaged in invidious racially and sexually discriminatory practices. It's also a law firm that has participated in the weaponization of the legal system against American principles and values. And we believe that the measures in this executive order will help correct that. Taken action.
Sign it, baby. So Trump signed it, and here is what it looks like published for us over at the White House. Says, by the authority vested in me as president of the United States, says, my administration, Trump, is committed to addressing the significant risks associated with law firms, particularly so-called big law firms that engaged in conduct detrimental to American interests. Many firms take actions that threaten public safety and national security, that limit constitutional freedoms, degrade the quality of American elections, undermine bedrock American principles. And moreover, law firms regularly conduct this harmful activity through their powerful, quote, pro bono practices, earmarking hundreds of millions of their clients' dollars for destructive causes like green projects, democracy projects, immigration, whatever, right, to wreck the country, that often directly or indirectly harm their own clients as well. Lawyers and law firms that engage in this egregious conduct should not have access to the nation's secrets, no. Nor should this conduct be subsidized by taxpayer funds or contracts. Couldn't agree more. Cut them out. They can go, if they do such amazing work, they can go survive on their own without grifting off the government teat. Jenner and Block, called Jenner, is yet another law firm that has abandoned the profession's highest ideals, condoned partisan lawfare, and abused its pro bono practice to engage in activities that undermine justice and the interests of the United States. For example, Jenner engages in obvious partisan representations to achieve political ends, supports attacks against women and children based on a refusal to accept the biological reality of sex, and backs the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs within our borders. And moreover, Jenner discriminates against its employees based on race and other categories prohibited by civil rights laws through the use of race-based targets. Trump's EO continues, saying in addition, Jenner, the law firm, was, quote, thrilled to rehire the unethical Andrew Weissman after his time engaging in partisan prosecution as part of Robert Mueller's entirely unjustified investigation. Weissman's career, you see him on Jen Psaki all the time, has been rooted in weaponized government and abuse of power, including devastating tens of thousands of American families who worked for the now defunct Arthur Andersen LLP, only to have his unlawfully aggressive prosecution overturned by the Supreme Court. The numerous reports of Weissman's dishonesty, including pursuit of non-existent crimes, bribery to foreign nationals, and overt demand that the federal government pursue a political agenda against me, is a concerning indictment of Jenner's, the law firm's, values and priorities. Andrew Weissman blown out by presidential executive order for all eternity, and deserves every bit of it. Says here, the Attorney General, DNI, and other heads and executive departments shall immediately take steps consistent with this order and the applicable law to suspend any active security clearances held by the lawyers at Jenner. By the Office of Management and Budget shall identify all government goods and property, including SCIF, provided for the benefit of Jenner, and get rid of them. To prevent the transfer of any federal taxpayer dollars to these law firms who are racially discriminatory, the government contracting agencies shall do whatever they can pursuant to the law to end it. And if you're doing business, if you're a law firm, if you're an agency who's doing any business with this law firm, you better let us know. Sign and disclose that so we can cancel the contract. Also, terminate what we can. Jenner, if they've been hired to do anything, right? So all the contracts canceled. Ugh. They must just be freaking out over there. I couldn't make me happier. Otherwise, align their agency funding decisions with the interest of the citizens, with the goals. Within 30 days of this order, agencies shall submit more, saying if you're doing business with them, let us know. Nothing in this order shall be construed to limit the action authorized by another order with Perkins Coie. And all agencies shall be permitted to limit official access to government buildings. Oh, so in addition, the heads of agencies shall provide guidance limiting their employees. And Andrew Weissman is now banned. Afuera. You're not going in there and having your little coffee dates with your FBI pals anymore, Andrew. Your national security pals. No. You're banned. Get out. Agencies shall, to the extent possible, refrain from hiring employees of Jenner, including but not limited to Weissman. He's going to sue. I think they'll start suing individually. I'm being attacked individually. No, they don't have to hire you, you hack. Absent a waiver from the head of the agency, made in consultation with the director that shall hire or threaten the national security. It's perfect. I like how I think that they're slowly getting a little bit more aggressive. And like we read the Perkins Coie one, but I don't think that they said that Mark Elias was banned from the building in that one. Did they say that one in that one? Maybe. He should be. Hopefully he is. He doesn't work there anymore. But maybe it's because they rehired Weissman. Okay, that's probably why, because Mark Elias doesn't work at Perkins Coie anymore. So nothing in this order shall be construed to impair or do anything else. Absolutely amazing. So Andrew Weissman gets blocked. Jenner and Block gets blocked. And this makes me very happy because the legal institution of the law has been so blue my entire life. It's just been wild to see it. Not necessarily the Supreme Court per se, which is interesting. You know, that kind of has ebbs and flows. But like this, the state bars, the American Bar Association, the National Association of Criminal Defense Lawyers, like all these entities, all these multiple letter entities, blue. Law schools, blue as can be. And so the law firms are operating in the same way. And a lot of that is being funded by us. We're paying for that. So how about we create some other legal entities that are a little bit less partisan and they can get the funds, or we can just give these funds to people who are conservative lawyers who actually love the Constitution, not want to exploit the justice system with guys like Andrew Weissman for their own gains. Now, we've got more executive orders coming up. President Trump also signed an executive order to declassify FBI files related to Crossfire hurricane, the Russian collusion hoax perpetrated by corrupt lawyers and Hillary Clinton and the Democrats.
Next, sir, we have a presidential memorandum for your attention. This memorandum requires the immediate declassification of all FBI files relating to the Crossfire hurricane investigation. This was obviously one of the instances of the weaponization of law enforcement powers of prosecution against you and others. We believe that it's long past time for the American people to have a full and complete understanding of what exactly is in those files.
Which gives the media the right to go in and check it. You probably won't bother because you're not going to like what you see. But this was total weaponization. It's a disgrace. Should never happen in this country. But now you'll be able to see for yourselves, all declassified. Is that correct? Would you say? All declassified?
Yes, sir.
Everything?
The FBI file with there's a classified annex, but other than that, this we'll put everything in the public eye.
Is anybody going to look? What about you? You going to look? And frankly, the FBI should be ashamed of themselves, and so should the Department of Justice, and so should Biden. Okay?
They should all be ashamed of themselves for what they did in trying to smear Trump. Now, let's take a look at that executive order itself, because here it is, a little bit shorter. Says, from the president, the order, immediate declassification of materials related to the FBI and Crossfire hurricane. Says, by the authority invested in me as president, vested in me, I hereby direct the following, except as provided below. I have determined that all of the materials referenced in the presidential memorandum of January 19th, 2021 are no longer classified. All right, so that seems like it's a narrow subset of files. Now, I have further determined that the material proposed for redaction by the FBI in a cover letter dated January 17th remains classified. What is that and why? My decision to declassify the materials described above does not extend to materials that must be protected from disclosure pursuant to orders of the FISA court. What? And does not require the disclosure of certain personally identifiable information and other materials that must be protected from disclosure under applicable law. Yeah. Subject to the exceptions identified above. This is for you, Pam! The Attorney General shall make declassified materials described in this memo available to the public immediately. So it better be out, like, now. So we'll see if it is. But, all right, a little underwhelming, I would say. Why don't we see the FISA stuff? Why does everybody protect the FISA court? It's so irritating. Even today, during the intelligence briefing, they were giving them layups, all the Congress people from both sides. Tulsi, can you explain how much you love FISA? Oh, yeah, sure, Senator. I love FISA. To all of them. It's ridiculous. Can we see it? No, because once we see it, it's going to be like walking out of Plato's cave, waking up from the Matrix, whatever analogy you want to use. It's going to be horrific. But they love it because it gives them power over us. Then we got another executive order. Trump issuing an executive order on election integrity. This one we definitely need. The Democrats do everything they can every single election to try to rig the outcome, but not anymore. Here's what Trump is doing.
Lastly, sir, we have an executive order for your attention on the very important subject of election integrity. We believe that this executive order is the farthest reaching executive action taken in the history of the Republic to secure our elections. Among numerous other aspects of this executive order, this is going to cut down on illegal immigrants on the voter rolls, ensure that the Department of Homeland Security and the data that they have available is being fully weaponized to ensure that illegal immigrants aren't voting. This will include a citizenship question on the federal voting form for the first time. This executive order instructs the EAC to cut federal funding to states that don't take reasonable steps to secure their election. This calls on the Department of Justice to vigorously prosecute election crimes, particularly in states that we don't believe are in compliance with federal law around election integrity. I could go on and on for a while, sir, but the compliance with National Election Day rules, cracking down and investigating and prosecuting foreign interference in our elections, revoking President Biden's Executive Order 14019, which essentially weaponized government to corrupt and pollute our election process. There's a lot in here, but we believe that these are very important steps that we need to be taking as an administration at your direction to ensure that our elections are as secure as they possibly can be.
Okay, you all understand that? Yes. Election fraud, you've heard the term?
Yeah.
Ended, hopefully. At least this will go a long way toward ending it.
Yeah,
there are
we'll
other
try.
steps that we will be taking in the coming weeks, and we think we'll be able to end up getting fair elections. Perhaps some people think I shouldn't be complaining because we won in a landslide, but We got to straighten out our election. This country is so sick because of the election, the fake elections and the bad elections. And we're going to straighten it out one way or the other.
And the tens of millions of people who they brought
And it's
into
an honor to sign this one.
rig the elections and
Sign all
future
of them, but
elections.
to sign this one is a great honor.
Thank you, Mr. President. We appreciate that. We need our elections secured. Now, we got a big one here. Let's hit some of the highlights from this new executive order. By the authority vested in me, here's what we're doing. Here's the purpose and the policy. Now, despite pioneering self-government, which we did, the United States now fails to enforce basic and necessary election protections employed by modern developed nations, as well as those even still developing. India and Brazil, for example, are tying voter ID to a biometric database, while the U.S. largely relies on self-attestation for citizenship. In tabulating votes, for example, Germany and Canada, they require the use of paper ballots counted in public by local officials, which substantially reduces the number of disputes. As compared to the American patchwork of voting methods that can lead to a basic chain of custody problems because Fannie is responsible for transporting the records and the voting ballots. Further, while countries like Denmark and Sweden sensibly limit mail-in voting to those unable to vote in person and do not count late arriving votes regardless of the date of the postmark, many American elections now feature mass voting by mail, with many officials accepting ballots without postmarks and those received well after Election Day. Free, fair, and honest elections marred by fraud, errors, or suspicion are fundamental to maintaining our constitutional republic, says Trump. The right of the American citizens to have their votes properly counted and tabulated without illegal dilution is vital to determining the rightful winner. And so under the Constitution, state governments must safeguard these elections. Federal law protects American voting rights and guards against dilution by illegal voting, discrimination, fraud, and other things. But the United States has not adequately enforced the federal election requirements, for example, that prohibit states from counting ballots received after Election Day or prohibiting non-citizens from registering to vote. Federal law already establishes a uniform election day across the nation. It's the policy of this administration to enforce those statutes and require that votes be cast and received by the election date. As the United States Court of Appeals has said, those statutes set the day by which ballots must both be cast by voters and received by state officials. Yet numerous states fail to comply with those laws by counting ballots after Election Day. This is like allowing a person's to arrive 3 days after Election Day, perhaps after a winner has been declared, to vote in person at a former voting precinct, which would be absurd, obviously, right? You couldn't do it in person. Why does it count after the election is over if you mailed it? Several federal laws, including 18 U.S. Code 1015 and 611, prohibit foreign nationals from registering to vote. Yet states fail to adequately vet their citizens. And in recent years, the DOJ has failed to prioritize and devote sufficient resources to enforcement of those provisions. Even worse, the prior administration actively prevented states from removing aliens from their voter lists, obviously. Now, additionally, Trump says federal laws like this one and that one require states to maintain accurate lists. Homeland is required to share the database under that law. They got to maintain accurate lists. This law prohibits foreign nationals and more. Above all, elections must be honest and worthy of public trust. It requires voter methods that produce voter verifiable paper records and protect against fraud. Election integrity standards must be modified accordingly. And so you can see it's a big order, bunch of stuff. Section 2 is about saying we got to enforce citizenship in federal elections. Lots of rules around that. Section 3, other assistance, provide assistance to states who are verifying records like a master death file, number verification services, improving the election commission, prosecuting election crimes. There we go. The Attorney General, Pam Bondi, shall take all appropriate action to enter into information sharing to prosecute those who committed election fraud, registered to vote multiple times or registered despite being ineligible, intimidated or threatened and did other things. We're going to improve the security of the voting systems. Tell that to Jenna Griswold in Colorado. And they shall take appropriate action to make sure we've got critical infrastructure that is secured. So a very big executive order, lots to unpack there, but we're happy to see some developments in the right direction. And they changed all these rules back during COVID anyways. A lot of the election rules have gotten insane recently because of COVID. And the judges usurped the legislatures who controlled the time, manner, and place of the elections and took it into their own prerogative, just like they're trying to usurp American power now. Now, one also shocking thing that happened today was that President Trump issued a pardon for Devon Archer. This was a Hunter Biden former business partner who was prosecuted by Joe Biden, Hunter's daddy, and incriminated Devon Archer, probably because Devon Archer was getting outside the fold of the Biden family. And this whole thing is going to be wild. Devon Archer getting a pardon makes one suspect that Devon Archer is going to start spilling his guts on what Joe Biden did and how corrupt he really is. We're excited for that. Here's what happened in the White House.
First, we have a pardon for Devon Archer. Devon Archer was a former business partner of the Biden family. He's was prosecuted relating to a fraud investigation, but notably the tone and tenor of that prosecution changed dramatically after he began to cooperate with congressional investigators and serve as a witness against Hunter Biden and the Biden family. We believe that was an injustice, and therefore we're asking you to pardon him.
And many people have asked me to do this. I think he was treated very unfairly. And I looked at the records, studied the records, and he was a victim of a crime, as far as I'm concerned. So we're going to undo that.
Very interesting.
All right. That's Devon Archer. Congratulations, Devon.
Very interesting. So Joe Biden pardoned his son after saying that he would never do it. Hunter and Devon were pals for a long time. Daddy pardons Hunter and prosecutes Devon. Then Joe Biden loses. Trump comes in, pardons Devon, who Biden just prosecuted. Very interesting. We're going to see what happens next with
First, we have
Devon Archer, and we're sure more will come. But we also have Congress that is stepping in. What do we do about these judges? What do we do about all these problems? Is Congress going to do something about it? Yeah, we got Mike Johnson saying, how about we just defund them? Here is the leader and Speaker of the House.
It's not what the founders intended. So there's a natural tension between the branches of the government, and we're working through that. The Judiciary Committee is looking at alternatives. One of the bills that I really like that's already been through committee was authored by Representative Darrell Issa, and that would limit the scope of federal injunctions, the ability of one individual judge to abuse the system in this way. And it would be, in my view, a dramatic improvement on that. So we'll be moving, I think, that piece of legislation and some others to address it, because we have an Article I authority under the Constitution to do that. We do have authority over the federal courts, as you know. We can eliminate an entire district court. We can have power funding over the courts and all these other things. But desperate times call for desperate measures, and Congress is going to act. So stay tuned for that. Thank you.
All right. Congress is going to act. And Jim Jordan was also out, hanging out with Rob Schmidt over on with Newsmax. And Jordan was asked some questions about Boasberg and the judiciary. Here's what Jim had to say.
Story, doesn't it? It sure does. These judges, I mean, the left's being the left. They actually think that unelected judges, unelected bureaucrats should have more say in policy and actions than the guy who put his name on a ballot and got elected as president of the United States as commander-in-chief. So, and then when you look at this Judge Boasberg's decision, it was one of the dumbest I've ever seen, because he in essence said, turn the plane around, bring back the bad guys. Bring them back to gang members, hardened criminals here illegally who did terrible things, turn the plane around and bring them back. dumbest thing I've ever heard. So we're going to be talking about that, as well as these injunctions that you mentioned that have happened so often around the country.
Dear Lisa has a bill to block district judges from issuing these nationwide injunctions. Why should some partisan judge, probably in a very partisan area, be able to stop something from happening all across the country, be able to prevent the president from doing the work to the entire country? I think that makes sense. It's amazing to me that that is the way it works.
Yeah, no kidding. I always say, why should some judge in Timbuktu, California, be able to decide policy for the entire country? So that bill, good bill, we've already passed it out of committee. We had a hearing on that. We talked about that. We passed it, taken a vote, and it looks like our leadership is going to put that on the floor for a full Congress, for a vote in front of the full Congress next week. But it's a good bill. It says the decision should apply only to the parties in the case in that respective jurisdiction, shouldn't have nationwide implications. And if there are a couple of state attorney generals bringing in action, well, then it goes to an expedited appeal process. Again, legislature will be trying to put some common sense back into this and let the president get his policies done that he was elected to do.
I mean, you're head of the Judiciary Committee. I mean, it's in your opinion, because there's conservatives like Andrew McCarthy we talked about last week that say that the president is not on solid legal ground in this decision that they've made. How do you see it? I mean, what's your?
I respectfully disagree. I think he's on strong constitutional ground. Article 2, Section 1, first sentence, executive power shall be vested in a president of the United States of America. So this is the president. He was elected. This is his power, particularly when you talk about national defense. Second, the Alien Enemies Act talks about a predatory incursion as a reason the president can take this type of action. Well, what else do you call this gang? Trinidad Agua gang coming in here doing the terrible things they're doing. They're not coming in here because they're Boy Scouts wanting to do nice things. They're here for bad things. And they've done those things, and they're here illegally. So I think he's on strong statutory ground. And then finally, it's what we talked about before. It's this decision is stupid. And then when you couple the fact that this Judge Boasberg, has a history which looks like it's been politically targeted against President Trump, specifically what he did with on the FISA court relative to the whole Trump-Russia collusion baloney. I think you put all that together, and you can begin to make the case. This judge looks like he's operating in an entirely political fashion, which you're not supposed to do when you sit on the bench.
It seemed to me a little screwy when we found out that he was basically a tourist for I think the Trump court proceedings in Washington. He went in, even though that wasn't his jurisdiction, he went in just to watch the president go through this process, and it was almost like he was a fangirl for the prosecutions of an ex-president, which I
he
thought
also
was
gave
telling.
Also, Rob, that is important, but he also gave the slap on the wrist. He was part of giving the slap on the wrist to Kevin Kleinsmith, the guy who altered a document that was taken to the FISA court and was used to get the warrants to spy on President Trump's campaign. Right. I mean, come on.
Yeah, exactly. I wanted to give this to you before I let you go.
All right, so Jim Jordan out there explaining what is happening in Congress, and we're excited to see them get to work, holding these judges accountable, passing some legislation to backfill what President Trump is already doing and achieving. We could use some help while we've got both houses of Congress. Let's codify this stuff and ensconce the winning for eternity. Now, some people out there get nervous. They say Trump is doing a lot. The Europeans don't like us. They're screeching on MSNBC. There's group chats. Everybody's freaking out about everything. Because that's what the media does, is they're just filled with hysterics who are hysterical all the time. But the truth is, even CNN can't hide reporting that the people like what they're seeing from Trump. The country is on the right path, and people can feel it in their bones.
I think sometimes it's important to do a little bit of reality check and take a little different spin at the numbers. I'm going to do that right here, because all we talk about is how unpopular Donald Trump is. But in reality, he's basically more popular than he was at any point in term number one, and more popular than he was when he won election back in November of 2024. What are we talking about? His net favorable rating right now comes in at -4 points. Compare that to where he was when he won in November of 2024, when he was at -7 points, or March of 2017, when he was at -10 points. So when you compare Trump against himself, he's actually closer to the apex than he is to the bottom of the trough. And of course, that's so important because Donald Trump historically speaking, has had his numbers underestimated. So I think it's very important to compare him to himself to understand he's actually more popular now than he was when he won, or certainly where he was at this point back in his first term. The bottom line is Trump is more towards the ceiling than he is towards the floor.
So when you do that, it makes my knees hurt. So when you look at this compared to sort of historically, what does it tell you about the percentage of folks that think the country itself, with him at the helm, is on the right track?
This, I think, is rather important because, again, if the polls have historically underestimated Donald Trump, what is a metric that might get at understanding at how popular he may actually be? So let's take a look at the percentage of the country who say that we're on the right track. It's actually a very high percentage when you compare it to some historical numbers. What are we talking about? According to Maris, 45% say that we're on the right track. That's the second highest that Maris has measured since 2009. How about NBC News? 44%. That's the highest since 2004. Wow. The bottom line is the percentage of Americans who say we're on the right track is through the roof. Whoa. And if you were to compare it to when presidents have historically been reelected, of course, Trump is not constitutionally eligible to run for re-election, but I think it sort of puts it in perspective. 42% of the country says the country is on the right track when the incumbent party is re-elected. And also keep in mind, back when Kamala Harris lost and the Democrats were turned out of power, only about 27 to 28% of the country said the country was on the right track. The bottom line is right now, a much higher percentage of the country says we're on the right track. And finally, Sarah Seidner, I want to put it all in the congressional generic ballot.
What about Congress?
What about Congress? Because those are the folks who are up in 2026. And take a look here. The Dems versus the Republicans on the generic congressional ballot. Back in November of 2020, when Democrats won, it was +5 Democrats. Tied in November of 2022, +1 in November of 2024 when Republicans maintain control. And then you look at March of 2025. This number looks a lot more like 2022 or 2024 when Republicans won control of Congress. The bottom line is, yes, Donald Trump's approval rating is lower than compared to a lot of his predecessors, but it's higher when compared to himself. A lot of folks say the country's on the right track, and the generic congressional ballot looks a heck of a lot more like when Republicans win than when Democrats win.
Nice updates from CNN. So you can add even more numbers and more margin to that, because I think that there is a silent contingent that is not captured in those numbers. But Trump is leading the way, and I think that the support that he has is not being translated well in the media. They're screeching. The headlines are that there's, chaos and fire all over the place. But the American people know that the administration is actually delivering. And so, my friends, it has been a beautiful stream. If you're just joining us, let me do a quick recap so you can see what you can rewind to and capture. We talked about Judge Boasberg and how the Trump administration, the Department of Justice, Pam Bondi, Kristi, Noem, Marco Rubio, all invoking the state's secret privilege, saying, sorry, Boasberg, we're not giving you anything. You've gotten enough information. You don't need the details on the flight logs and when it landed and took off and all the things. You've got plenty. Stop being a hack. We also then saw that the Trump administration asked for and received a stay out of the Fourth Circuit. And this was a big blow to Norm Eisen and his blue team lawyers who sued to try to stop Elon and Doge from going in and making the cuts. The judge out of Maryland granted those limitations, stopped Trump from making those cuts, and now the Fourth Circuit came out and issued a stay saying that Trump doesn't have to follow the injunction from the lower level judge. So good developments there. Pam Bondi's very happy about that one. And then we got a whole slew of executive orders that came out today. Trump signed one targeting Jenner and Block, the firm of Andrew Weissman, who is a big fan of Inside Jen Psaki's TV show. We also saw Trump declassify some Crossfire hurricane documents. Looks like it's kind of a small batch based on the executive order, but maybe more will be coming out after that. We'll see. We also then got a big executive order on election integrity, which has been something we've been covering here for a long time, back since during COVID and the aftermath of 2020. And Devon Archer got a pardon. So we're expecting him to do a podcast circuit and explain everything that is happening with Joe Biden and the Democrats and what they tried to do with him. We're looking forward to learning more about that. Meanwhile, Congress is saying that they're going to start opening up hearings on these judges and maybe do something about it, because I think that they're probably realizing they're on the right side of this. The American people will benefit them at the polls if they jump in here and provide some relief. But my friends, it has been a beautiful stream. Thank you for joining us on this incredible Tuesday. I hope your week is unfolding beautifully. But now it's time to hear from you and see what you have to say about this. Thank you for supporting our work by becoming members, joining us for our members-only streams in the morning. Thanks for inviting other members. Thank you for sending in these super chats. You guys are amazing. We got some great comments in here. Look who's here. What's up, Waldo? Is joining us, and here we go. It's Tuesday with Cookie Monster. We love Cookie Monster. Who doesn't love cookies? Thank you for that. Hey, Lisa Halmiser. What's up, Lisa Halmiser? Thank you for becoming a member. We had a great members-only stream this morning, and we're going to have another one tomorrow morning. Can't wait to see you. What's up, Sua Sponte? It's my 1-year anniversary. Happy 1-year anniversary to Sua Sponte and to all of us here. Happy anniversary, Sue. Thanks for hanging with us for a full year. It's been a doozy. This year's been a doozy. I know you know. Hey, we got 2 babies here from Ray Ronk. Wow, 2 babies already. It's a lot. Think about that. 2 full babies here, Ray. Yeah, we've seen some serious stuff. Got some more gray hairs, I think, on my head for sure. Hard to believe it, Ray. I know. Wait till we get to our 3rd. Gloria says, hey, Gloria Chamberlain is coming in. Gloria B, bringing in 1 new member. Laura Chamberlain, welcome, Laura, and thank you, Gloria. Hey, Michelle. Trump should sign an executive order saying all district judges have to wear an eggplant foam hat when on the bench. Make the court explain the separation of powers. That's a great point. Yeah, an eggplant foam hat for national security. All judges have to wear it. A big one, too. Big fat eggplant on there, you know. Droopy, dangling in their face. So when they're making rulings, they have to like move it. They're like, what, counsel? Can you please come up to the mic? I can't hear you. Droops right back into their face, you know. Be strange. Strange proceedings. Hard to get anything done. Hey, what's up, Waldo? Thanks for bringing in 10 membos, Waldo. Look who's coming in. Professor Falcon is here. Someone out there. Julie Ferrier. What's up, Tilla World Girl? We got Wayne Hinson, Sal Sadler, Gritty Gret, Wayne Coulter, Tripping Over Trauma in the house. Just Rhonda saying welcome. Lots of people saying thank you to Waldo for bringing in 10 new friends. Thank you, Waldo, for doing that and for being a member yourself. Hey, KC Cat says, we really need to know if Chief Justice Roberts and Jay Baloney Barrett, that's pretty funny, are truly meeting secretly, regularly with these rogue judges. That smells like a coup or treason. Yeah, I'm sure they're in private clubs together. I don't doubt that for a minute. All right, I'm sure they go to little cocktail parties and have their wine spritzers and drink with their pinkies up and all the, it's how the law is in general. Then you get to that level, golly. Hey, thank you for the dono, Casey Cat. Knox says, hey, happy Tuesday, all. I was wondering how long the state would put up with this judge requesting transport info. Our jail is so full. Knox is a defense attorney in Texas, saying that with 60,000 people, that inmates must be shipped out to Louisiana or Mississippi county jails on the weekend to make room for the weekend arrests. I never get told who will move or where due to security issues. Yeah, but now this judge wants all the details from federal transportation of terrorists just dropped down to his desk. No thanks. Sheila Poo, great comment, says, awesome filing. Tell those judges to go pound sand. Yeah, Trump's getting there. That's basically where we're at now. But legally, he's not violating a court order. He's saying, I'm legally invoking a power to reject your order. So do something about it. Hold me in contempt or sanction me or whatever. We'll see what comes next. Londo. Why can't Jeffrey Goldberg be charged with espionage for acquiring classified information, his claim? Aside from holding the proper clearance, the principle of need to know requires contractors to hang up and report such errors as Goldberg experienced. All U.S. citizens have an inherent duty to protect national secrets. Reporters are not excused, and his persistence in lurking on the call or in the chat after realizing he did not belong there should leave him open to prosecution. What do you think? Well, there's a similar concept in the law, right? So we were talking about this on the Membo stream this morning. If a lawyer inadvertently gets materials like from a court or from opposing counsel that they should not get, like they meant to send it to a colleague, but they sent it to you, you're the opposition, you have a duty of candor, right? You have a duty to not look at that and to tell the other people about that so they stop sending you stuff like, don't send that to me again. And I think there's ethics cases where like lawyers just kept allowing them to send it, you know, like, oh, don't tell them it's the wrong email. Like sending another email, next day, another email. Here's our strategy. Here's our strategy. Here's our strategy. You have a duty of candor to not be involved in that stuff. Now, journalists are a little bit different, right? You kind of expect them to blow the whistle on these things. But yeah, Jeffrey Goldberg's a piece of work. So you can't trust anything he says. What's up, Doan? Says jurisdiction is the hardest word on this topic. Jurisdiction is their hardest word on this topic. Yeah, they don't have it. So they like to tap dance around it, don't they? Thank you, Doan. Sheila Pooh says SCOTUS needs to get off of their booties and resolve this by protecting Article 2 powers of the president and do it now. Yeah, do you hear that, John Roberts? Sheila has a message for you. And me too. Do something. They're going to do something. It's just going to take forever. Gosh. Hey, Debbie O says, for fun, tagged you on X with a video of Big Fanny and Wade traveling together at LAX. Like, is it a real video of them or is it some meme of Fanny and Wade? Because some of those Fanny memes are, wow. You know, like Fanny's like Shamu at SeaWorld or something. It's hilarious, but they're pretty prickly. Hey, what's up, Debbie? Debbie O, what a nice Snoopy here. Debbie O, thank you. Says Debbie O, what's up? Southern Meemaw gifted a memo. Debbie's bringing in 5. Rachel Holzer, Mackie, Eden Heidick, Eden. Leave that one. John Paul Bouliane, what's up? And Just Rhonda, a purveyor of fine emojis, who's also on YouTube right next door. Check her out. Thank you, Debbie, for bringing in 5 new membos. G-Men says, is there any way to challenge jurisdiction under the AEA? Texas clearly has jurisdiction for habeas, since that is where they are being held. Can a court in Texas remove the case from DC and pull it into their jurisdiction? No, I don't think that that's how that would work. So like Texas can't, they're not going to go in and take it. But Trump has been making this claim. They've been saying that they should be filing a habeas petition. I mean, they're challenging this right now. In fact, I think that was the subject of the Court of Appeals argument yesterday, was that Trump appointee was saying that they don't have jurisdiction over this, that it should be filed in Texas if they want a complaint. So it would be to dismiss this lawsuit on the basis of jurisdiction, and the same plaintiffs would be forced then to file back in Texas. So they're challenging it, but the judges don't care, right? The same thing is happening. So this is the response to the people saying strip them of jurisdiction. They don't have it in many cases. Like the Court of some judges have found that. The Court of Federal Claims judge, one of the other judges, said that they should have sued in the Court of Federal Claims in DC, dismissed the case, or denied the TRO. Doan, do we lay off Pam while she collects enough evidence to get solid convictions and lasting results? It's been 2 months and justice's wheels grind slow. Well, both things are true. Like, yes, the answer is true. And you sound like a very nice and, diplomatic person who is showing her the benefit of the doubt. And you've heard me make that argument. We're kind of split personality on this. All right. So yes, the law grinds very slowly. And yesterday we got into this where I was explaining that lawyers will regularly say the hardest job in the world is to just be patient and wait. We're doing that with Pam. But we're also going to be very obnoxious clients. We have the right to be obnoxious clients. We can call every couple of days. Is there an update in my case? Lawyers know. Right? Is there an update in my case? No, there's no update. Is there an update tomorrow? No. Okay, I'll call you back tomorrow to see if there's an update. Don't call. We're not going to have an update for 30 days, okay? Because we just filed all of our paperwork. It takes them 30 days to read it. Anyways, all the lawyers out there know what I'm talking about. We don't have an update. So we can call, we're calling in this show, we're calling Pam Bondi every day. Do you have an update on my case? Is my settlement check come in yet? Has the prosecutor responded yet? Did they dismiss my case? Where's my settlement check? That's who we are to Pam. Where are the files? Where are the files? Where are the files? Is there an update? Hey, Cornell, in camera. Yeah, in chambers, right? Good. Thank you for the link there, Donut. Aaron Brodsky. What's up, Aaron Brodsky? Welcome aboard as a supporter. Thanks for being here. We'll see you tomorrow on the Members Only stream. Tammy the Third says, I developed the drinking game where you take a shot every time Rob says percolating. I played yesterday, had to call out of work today. Well, there's stuff percolating everywhere, man. It's percolating out of our eardrums. It's everywhere. Case laws percolating, borders percolating. Wild. Tara Eggers had to quit drinking because I said percolating too many times. All right, message received. I'll come up with something else like incubating or matriculating or something. All right, I'll work on it. I'll come up with some synonyms. Thank you for the notice. Hey, what's up? Marion Holtzman. Hey, Rob, haven't watched you in a while. I'm just trying to stay calm. Thank you for continuing to fight for us. Hey, Marion. First of all, thank you for the very nice dono. Very generous of you today. And yeah, I think it is an appropriate time for calm. Okay, we've got the football. We're up by 100 points. We have a bunch of really incapable, incompetent people who are having fleeting victories right now. They're just fleeting. The courts of appeals are going to settle a lot of this, and the Supreme Court will settle a lot of this. We're in this TRO process. They take, let's say, 90 days up to 6 months. By the time we get to 6 months, I think the Supreme Court is going to settle a lot of this. It's not, I think cope, or it's not us finding an excuse to stay calm. I do think this is how it's going to ultimately come down. It is also infuriating. I'm not trying to minimize this because they're stealing time from us, right? They got mad over an insurrection, the peaceful transition of democracy, peaceful power. It was a 4-hour riot. They were back in voting that same night. It was 4 hours, 6 hours if you want to look. Round up, Rob. Stop rounding down. Okay, 6 hours, fine. Of stolen time from the government that we can't get back. They came in that night, voted. These are months of time that are being stolen from us by federal judges under the guise of due process and equal protection. And it's nonsense, right? They didn't impose these same stringent requirements against stopping government orders when it was COVID time, right? So, but when it's border, when it's terrorism, suddenly it's a whole different standard. And now Trump needs to give everybody individual hearings. So Spuds shared in some just gigantic dude says, I think this dude needs a man's ear. Yeah, or a bro. Do you prefer bro or a man's ear? Which one? Karen Wolf. Hey, Karen, thanks for becoming a membo. We appreciate you signing up. See you tomorrow morning, and grab the stream from this morning, membos. Hey, KC Cat is here. Says, Congress should defund the D.C. District Court. Yeah, look up the history of the D.C. District Court. It's changed a bunch of times. It really, I think, became a federal court like in the 1960s. Lincoln got rid of it. It's terrible. It's much quicker than impeaching one at a time, and it clears the cesspool. They are not above the elected president of the United States, and they have gone rogue. Yeah, I'd be totally fine with getting rid of the D.C. District Court. Our friend Bonnie on Locals did, I think, an AI analysis on it, and it's like 3-1 Democrats to Republicans there at the district court level. FD Man, what's up, FD Man? Says, Secretary Noem, Secretary Rubio, AG Bondi told Crazy Eyes, Judge Crazy Eyes, to eat it! Yeah, which judge is Crazy Eyes? Does Boasberg have Crazy Eyes? I don't think he has as crazy eyes as like Griswold or it was really like Griswold. It was the Secretaries of State who really did. Jocelyn Benson, remember her? I think she's running for governor now. Londo, Musk is no more imposing than a welcomed Trump dinner guest. They have no case. Musk is a nice guy. He brings his kid with him. What are you so petrified for? Relax. Miss B. What's up, Miss B? Thanks for the dono. My hero. Thank you, Miss B. You're my hero. Hey, and it's Gonzo over here. That's like the eggplant hat we were talking about with the judges, right on their faces. Hey, Jason Duncan. What's up, Jason? Thank you for becoming a membo and supporting us. Shout out to our friend Jason. Will Crump says, the lefties trying to say the Constitution only says Congress can create courts. If Congress can bring them into this world, Congress can take them out. Yeah, you even heard that from Mike Johnson, right? He said, yeah, we'll just get rid of them. Get rid of the courts. Maybe they'll do that. Hey, Doanne is here. Says, we were ruled by an auto pen for 4 years. So what's their beef with an actual identity saving $1 trillion in taxes each year and busting career criminals? Well, their beef is that they were in the grift of the auto pen. Like the auto pen was signing their checks, essentially. So that's why they're mad. Yeah, it's because they're not getting their money anymore. Yeah, G-Men says the Ninth Circuit also overturned the activist judge who halted Trump from suspending all refugee admissions. All refugee admissions are now halted. Amazing update, G-Men. Yeah, I didn't see that one today come down. But lots of stuff flying around. Thank you, G-Men, for that. KC Cat says, please remember to hit that like button. Thank you, KC Cat. And thank you for doing it, my friends. Only if your thumb works. If your thumbs don't function, we would appreciate you trying to use your forehead to hit the like button. But if those three options don't work for you, we understand. Thank you. It does help the channel grow. We appreciate it. Thank you, Casey Cat, for saying that. Hey, Rob Maga Patriot says, what is Noem Eisen doing on Jen Psaki's face? I don't know. Tap dancing or something strange. Acid Burn. How's your family, Robert? They're great. Joey's great. Yeah, Joey's great. I think I talked to him last night. Was it last night? Yeah, I talked to him last night. He's doing good. He's doing good. I think I have to order him something on Amazon. Oh, cord organizers. He's got cords. Don't you hate how they get discombobulated all over the place? So Joey needs some cord organizers, which I will be ordering for him today. And show the dogs every now and then, which we don't have any dogs, but I'll get some for you. And says, thank God for Trump. Amen to that. FD Man says, hey, Trump to Andrew Weissman says, go eat it. You Democrat cog blocked hack. From FD Man. Thank you, FD Man. Hey, NY says, I don't feel bad about Weissman's ban. Me either. Did he speak out as a lawyer when Tulsi Gabbard was put on a travel ban? No. In fact, he said it was the right of Biden to point out threats for extra airport screening. Yeah, Weissman's a piece of work. And he just kind of parades himself around like he's this nice guy or something. And everyone's like, well, he's nice. He wouldn't be a dictator. He's pretty terrible. Yeah, what's up? FD Man says, go Trump to the media. Go check the FBI Crossfire BS papers, you jerks. Obama, Biden, FBI, and DOJ. I declassify all of your BS. From FD Man on Rumble. Thank you, FD Man. Hey, what's up? Acid Burn is here. Bringing in 5 membos. Acid Burn, thanks for doing this. Roberto Gomez coming in. Charla got gifted one. Harold Greer, Gavin, Nick, and Yiba gifted membos. Thank you, Acid Bird, for bringing them in. Hey, Thomas White, right. Thank you, Thomas. Says they're going to put up pics of Weissman and everyone else not allowed to enter government buildings at entrances. Let's use nationwide injunctions against the NFA. Democrats would be against them real quick. Yeah. They could put Weissman and Mark Elias on most wanted posters, right? Deny entry to these buildings. Sorry, sir. You're on the list. I like it. Yeah, we'll see. I don't know. I feel like Weissman is going to sue. Should be interesting. Hey, what's up? Acid Burn says, what a first 6 months of knowledge with you, Rob. Thank you for that, Acid Burn. It has been a beautiful 8 months or 6, whatever it is. We appreciate you being here. Sharpie Guy, Rob, please explain your disdain for FISA. Well, I think it's been abused by them. It operates undercover. It's operating basically outside of Fourth Amendment protections. And it's been abused and used to spy on Americans, including the Trump campaign, and nobody can audit it. It's illegal. That's my problem with it. FD Man says, today display put on by the Senate Democrats was a half a sissy tough guy talk by Powder Puff in overpriced suits. That's a heck of a statement there. Oh, I see. The Senate Democrat hearing with all the rest of the three. It was Cash, Tulsi, and somebody else was there. I'm having a mind blank right now. But yeah, they got Ratcliffe, CIA. NY. Yeah, they got hit hard today. NY says Trump admin on the zone. The election interference order will be fought in court, but masterfully, Trump then is able to get on the court record evidence of voter fraud, finally after being denied in the past. From NY. Acid Burn is bringing in 10 membos. Thank you, Acid Burn. We got Eki is here. Joel and Kathy Davison, Electric Messiah, Vegeta 100, Sippus MC retired. Pamela G, what's up? Sunshine is here. Marcus King. DC on X. Insight of the Ages and more gifted membos courtesy of Acid Burn. Thank you, Acid Burn, for doing that. And welcome new friends. We'll see you tomorrow. Sharpie Guy. How does the EO clean up elections in blue states? Well, I think he's saying that there'll be different types of enforcements, right? Trump controls the DOJ. Trump will control some money and contracts and things, so he can just refuse to do business with states that aren't. In other words, he can control some funding and some interfacing. We'll work with you if you do these things. We won't work with you if you do these things. So he can put some leverage and pressure on there from an enforceability operation. And I think throw money around. FD Man says, watch the DNC go insane over this pardon. They are going to lose their bananas over this one. Colleen says, to be a fly on the wall when Devon starts saying F you to the Bidens and letting all the stuff they've done with their fingers get out into the world. Yeah, it's going to be epic to see what he says. Acid Burn says 2 state police told on Bill Clinton and they went to jail. What's up, Eugene Sands? We got a full baby in the house. 9 months as a membo. Thank you for that, Eugene. Says full term. You helped me through a tough year, Rob. Hey, man, Eugene. I'm glad we got to do that together. Thanks for shouting us out on that. You guys have helped me through a lot of tough times. So glad to be here for you. Thanks for being here 9 months and hanging with us. Acid Burn is in the house. Acid Burn, bringing in even more membos. Look at this. Acid, thank you for this. We got Judge Maddie. Dean is here. Liz F. Wumpy. Maverick Mowers. We got Doug and Dallas coming in. Curious Kate. Jay Morrison. Margie M. Be Fine, a.k.a. Free Spartacus. And more here shouting out Acid Burn in the house. Acid Burn, thanks for bringing him in. Hey, Clint does improv over on Rumble. Thanks, Clint, for being a membo and watching us over there. Says, it's great that Trump issued an executive order about election integrity, but can we get back to a voting day and not a voting month or 2 months? That was in the order. Yeah, so that might be another thing. It's like there are laws on the books, and if your states are not counting the votes by that time, you're in violation of the law, right? And so the Trump DOJ can maybe bring a civil action against them saying their state election deadlines are in violation of U.S. law. Federal law says it's election day. State of New Jersey has election week. They're in violation of law. Trump's executive order says we're going to prosecute you for that, not criminally, but file a civil complaint and make the courts force the states to get back into compliance with the feds. Pinochet, will appeals courts take notice of the plaintiff's attempts to withdraw an injunction to avoid reversals and precedents? Yeah, is that not bad form or obvious what they're doing? Can sanctions be imposed? Yeah, so it's a great question. It's going to depend on the Court of Appeals. So what Pinochet is referencing is basically what's happening in the Hampton-Dellinger case, right? Hampton-Dellinger, as soon as the Court of Appeals issued a stay, then he's like, I dismiss my case, because he goes, oh, crap, they're going to rule against me. If they rule against me, then the Court of Appeals becomes binding on all the lower level district courts underneath that circuit. So people will file and try to stall Trump. Then when the Court of Appeals looks like it's going to issue a bad ruling, they pull their cases out. And I think you could always ask for sanctions, but I don't think that anything like that is going to happen, especially if the Court of Appeals doesn't want it to, right? If it's a friendly Court of Appeals that is reluctant to even hold against that plaintiff, they won't. But it's a great question, and it is being abused. Hopefully it stops. FD Man says, Richard Headhat. Sharpening Man in Texas says, what's up? Parker Kelly's coming in. James C. gifted a membo. Crypto Crackhead, welcome. Dizzy X Monster and Kevin Dory gifted membos. Sharpening Man in Texas, thanks for bringing them in. Hey, Diana Cooper is here. Just became a membo. Thank you, Diana Cooper. And David Dehart says, I just saw a report. Judge Boasberg was the one who gave Raps a slap on the hands. Is that right? Did he do on the virtual sentencing? He got to call into? Amazing. S. Quinn says, not sure what made me laugh more. The super caffeinated CNN guy or Robert showing us how the foam eggplant hat would look on the judges. Thank you both for that laugh. Yeah, that's how the foam eggplant would look, right? Be like, your motion is denied. All right. Next case. What's happening here? That's funny. G-Man says, so we treated Nazis better? Well, FDR executed 6 of them, including an American citizen in the D.C. jail after holding a military tribunal in the DOJ building. They were executed 3 days after being found guilty. Oh, really? The other 2, there were a total of 8, were granted clemency from execution to life in prison. Interesting read on the FBI website. There it is. Thank you, G-Man. Yeah, there it is. FBI Nazi saboteurs executed. Found guilty, executed. No real appellate rights for them. One guy was a citizen. Wow. No appellate rights. So that judge was wrong. Thank you, G-Men, for proving her wrong. G-Men, name of the case the Ninth Circuit overturned is called International Refugee Assistance Project, IRAP, versus Trump. G-Men in the house. Thank you for the details today. Appreciate those. Rob Maga Patriot is here. Says, problem with getting rid of the D.C. court is the judges stay, they just get moved. Well, that's okay. I mean, they'll have a very different welcome in Texas or wherever else they can go. Won't be in the incestuous DC environment. Hey, BH Williams says a bra is for ladies, a bro is for men. NY, what's up? Says FISA? Even after the abuses of FISA were made public, FBI agents continued to use FISA to spy on personal contacts, girlfriends, national security related searches. There's no evidence any of them were punished. Yeah, it's spying without a warrant. It is in violation of the Fourth Amendment, and it's illegal. And I don't care about their stupid protections. If they want to go spy on somebody, they can get a warrant from a judge. And they no, it's no time. It's too difficult for us to get it. It's so urgent. Give me a break. Shelby Girl. Well, Rob, you haven't captured terrorists. Okay, I'm sure. Yeah, I'm sure it's like Jack Bauer every minute. Shelby Girl, 66 GT 350. Thank you for joining up as a membo. We appreciate you joining as shout out level membo. Thank you for that, Shelby Girl. We'll see you tomorrow on the members only stream as well. My friends, thank you for sending those in. Really appreciate your support and your love. Couldn't do it without you. Grateful for you. We want to say hello to our friends on X before we go over to locals, watchingthewatchers.locals.com. Oh, Steve Sadow. Look, as soon as I opened up X, Steve Sadow popped up. Dang, pesky airport surveillance. Willis and Wade together again. Oh, those 2 little lovebirds spreading their noxious odor all over again, probably on a cruise somewhere. Wow. And Georgia just doesn't care. They like them. Hey, Mini Tika, what's up? Be Torn, Richard Tatership, great to see you. Hey, what's up, Chris Raid? Yeah, there they are. Big Fanny and Wade are back, baby. There they are, moseying around the airport. Look at them. Oh, gosh. Fanny's leaning over, tying her shoe, showing us her fanny. You know, generally you don't want to be filmed in public. You don't, if you're out walking around, you don't want to be filmed, but you can't really miss that. You can't really miss Fanny walking around an airport. Hard to miss. See what I'm saying? She stands out. You can't miss Fanny anywhere she's walking. So, and is that what she wears? Is that what she wear to the airport when you're an elected DA? That's what you wear to the airport when you're the biggest Fanny in Georgia? That's your outfit? Like you're wearing your yoga pants? We could have done without that today, but all right. We'll talk about it tomorrow. All right. Yeah, there's more. I think that there was another noxious odor. Wasn't one of her buildings evacuated today? I think a building was evacuated. I don't know if it was because a Fanny came or if Tish took her shoes off in the building or what. But yeah, it's rough. So thank you for that. Hey, Pliss Snakeskin is here. Richard Tatership. What's up, Robert the Great? What's up, Gary Seam? Says, will you follow Musk's lawsuit against the former Dem on CNN? Who was that? Yeah, if it's good. Yeah, if it's good, we'll do that. Hey, Jody, great show, Rob. I like Trump's auto pen better than Biden's. God bless. Thank you, Jody. God bless you back. What's going on, Richard Tatership? Good to see our friends over there on X. Thanks for joining us over there. Thanks for following other watchers in the wild on X and for being out there, my friends. We got this one from FD Man says, great question. Why is Nathan walking bow-legged? around the airport. What did Fannie do to him? Who knows? And why Fannie Willis, just friends with Wade. Was that perjury much? Yeah, Fannie said that their relationship ended. Remember? But you can't fight love, my friends. You can't fight love. All right, so we are going to end it there on the day. It has been a beautiful stream. I want to thank you for joining us. Thanks for hanging with us. Thanks for the great comments, the fun, the friendship. We are, of course, coming back tomorrow. Before we wrap it up, we want to thank our amazing mods and meme smiths. Of course, K Bean in the house, Donut, Carrie B, Playing Hooky, Dog Digger, Janek. We got Just Rhonda, Purveyor of Fine Emojis, Elliot, Docmaster, Jigum, Meme Smith. Thank you, everybody, for being here and for keeping the train on the track. My friends, we're going to pause right there for the evening. Of course, we're going over to Locals, watchingthewatchers.locals.com if you want to join us over there. Members, we're back tomorrow morning, 12 noon Eastern, for the member stream on YouTube and on Locals. Can't wait to see you there. But my friends, we are coming back here tomorrow. It's going to be an amazing Wednesday. We're going to get into it again. And in order to do it appropriately, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.